Hello, and welcome to Crime in Court. My name is Heather, and this is an update in the, it's a pretty recent update in the Karen Reed, Turtle Boy, Canton 9 case. So, I've been, putting updates, but, I pre-record these videos, so stuff happens before I can even, get it out. But, as we know now, Turtle Boy is out of jail. He's done his 60 days. He no longer has any restrictions about who he can and can't talk to. There's no stay away orders on those victims. That we'll call them victims for now. And then, so this episode is actually, like I said, it is an update in the Canton Cover-Up, Commonwealth versus Karen Reed. We're on episode 16. The Commonwealth doubles down on their lies, part 2. In part 1, we read through the Commonwealth's opposition to defendant's motion for sanctions. We read through the 25 whatever pages of their argument, and I said we would get to the exhibits next time, which there's a lot of exhibits. About 250 pages of exhibits. So instead of doing that, because just after I did my last video for part 1, this document came out, which has been now released publicly. This is the defendant's motion for sanctions and for disqualification of the Norfolk County District Attorney and memorandum support thereof. So we're going to read through this. This is good stuff. I'm kind of excited to bring this to you. There's a lot. There's just a lot. So this is all the crap that the Commonwealth has been doing behind our backs, behind closed doors, and now we're seeing the defense has shown a light on what's been going on. So we're starting to see that. So we're going to read through this and see what lies the Commonwealth has been perpetrating. So the defendant's motion for sanctions and for disqualification of the Norfolk County District Attorney and memorandum thereof. Now comes the defendant, Karen Reed, and respectfully urges this honorable court to sanction the prosecution for constitutional due process violations and for violations of ethical requirements imposed by the Massachusetts rules of professional conduct and for egregious misrepresentations to the tribunal and to opposing counsel. So they've been lying to us. They've been lying to you, Judge. They have been violating my client's rights. They've been violating the constitutional due process. Additionally, the defendant moves to disqualify the Norfolk County District Attorney because of his clear interest other than pursuit of justice in the outcome of the prosecution. In further support of this motion, the defendant relies on the arguments below. Facts: we know she's been charged with unaliving of second-degree manslaughter while driving under the influence and leaving the scene of personal injury and or unaliving in violation of all these statutes, all charges allegedly related to the unaliving of Boston police officer John O'Keefe in Canton, Massachusetts on January 29th, 2022. John O'Keefe's body was found outside 34 Fairview Road, Canton, the residence of a different Boston police officer, and the location of an after-hours party the night of January 28th through the 29th in 2022. The defendant's counsel have asserted in court filings and in court arguments based on evidence both developed by the defendant and disclosed by the Commonwealth in discovery, including the analyses of John O'Keefe's phone and the phone of a civilian witness also present inside 34 Fairview Road, that John O'Keefe had entered the 34 Fairview Road residence, that he was attacked inside that residence by a person or persons also present there, that Persons or also present in the residence were aware that John O'Keefe had sustained injuries inside the home and participated in a cover-up of what happened, and that other law enforcement officers, including a Massachusetts State Police trooper, multiple troopers, had participated in and furthered the cover-up of what happened to John O'Keefe inside 34 Fairview Road, including by planting incriminating evidence falsely implicating the defendant in John O'Keefe's end of life. So, I was going to back up a second. What did I want to say? Oh, this sentence here, including the analyses of John O'Keefe's phone and the phone of a civilian witness also present inside 34 Fairview Road. This could be anyone who was not a police officer that night. So it might have been, well, it couldn't be Brian Higgins. It could be one of the kids that was in the house. And I just, on Turtle Boy's latest, he just did a live stream, his first since he's been back out of prison or jail. And he said that he has it on good authority that the daughter, what's her name? Tristan? I don't remember. The boyfriend's Tristan. Gosh, Caitlin. I don't remember. There's so many people in this story. Anyways, the daughter of the Alberts was in the house, also Colin, and yeah, there were that's Sarah Levinson and Julie Nagel. It could be any one of those people's phones. It could also be Jen McCabe's phone that they're referencing this this civilian witness, the phone of a civilian witness. So it could be any one of those people. Potentially their phones somehow show that he arrived in the house. So maybe there was something on Jen McCabe's phone that indicated that he was there or something. I don't know. Maybe she's like, oh yeah, I see you, or whatever. I don't know. We don't know at this time. We don't know what that evidence is, but it would be awesome to figure that out. All right. So anyways, so as the court has explicitly noted, perhaps with understatement, the case has generated significant media attention locally and nationally. Memorandum of Decision and Order of the Commonwealth's Prejudicial Extrajudicial. Okay, so that came from the some court order that the case has generated significant media attention. All right, so the Commonwealth seeks and is denied an order, or a gag order, sorry. On June 9th, 2023, the Commonwealth filed its motion to prohibit prejudicial extrajudicial statements of counsel in compliance with Massachusetts Rules of Professional Conduct 3.6a Commonwealth motion, seeking to prohibit defendant counsels from making extrajudicial statements to the media that could be seen as prejudicial to the criminal proceedings, while simultaneously stating that the Commonwealth and its law enforcement witnesses agree to be bound by the same order guided by Massachusetts Rules of Professional Conduct, as well as according to all those rules of conduct. So they're saying the Commonwealth sought out a gag order to keep both sides quiet, but it really only helps the people that don't have the facts on their side. The gag orders do. So it just kind of goes to show what's going on. The Commonwealth's motion contended that statements it attributed to defendants' counsels about the defense theory about the cover-up by both civilians and law enforcement go further than zealous representation. They are unsubstantiated proclamations supported only by self-serving speculation and conjecture, likely not to be admissible at trial, and done with the intent of materially prejudicing the criminal proceedings by risking the impartiality of potential jurors. And that was in Commonwealth's motion. So the Commonwealth specifically contended that under the Massachusetts Rules of Professional Conduct, counsel is prohibited from making repeated extrajudicial statements that they know or reasonably should know have a substantial likelihood of materially prejudicing the, I can't say that, over and over again, potential trial jurors or witnesses. Prejudicing, something like that. All right, the court rejected the Commonwealth's contentions, specifically finding that the statements and arguments attributed to the defendant counsels can generally be characterized as responses to the accusations against the defendant and as pertaining to the theory of the defense, and the statements are therefore permitted under the rules. So everything that the defense has come out and said is under the rules. Order on Commonwealth's motion at 3, at line 3 or whatever, number 3. So this court further cautioned all counsel that they are bound by the rules of professional conduct and therefore subject to the sanctions in place for violating them. The order on Commonwealth's motion at 4, the court specifically admonished, in particular, counsel must be cognizant that statements commenting on the character, credibility, or reputation of a witness or conveying information which counsel knows or reasonably should know is likely to be inadmissible as evidence in trial are more likely than not to have a material prejudicial effect on the proceeding. I said it that time. See Gentile versus the State Bar of Nevada. Because lawyers have special access to information through discovery and client communications, their extrajudicial statements pose a threat to the fairness of a pending proceeding, since lawyers' statements are likely to be received as especially authoritative. People think a statement coming from an attorney or a district attorney, it has much more weight than coming from just an average Joe. All right, so order on Commonwealth 4 and 5. Accordingly, this court denied the Commonwealth's motion for a gag order on July 31st, 2023. So they sought this gag order and the court denied it. They said, you don't have what it is needed to prove that we need a gag order. They didn't meet their burden. All right, so the district attorney did I miss some? Yeah, I did miss the first footnote here. The court's order also specifically noted that adverse publicity from a law enforcement official provided to the media had the potential to endanger the defendant's ability to receive a fair trial, and that the rules of professional conduct provide for special responsibilities of a prosecutor with respect to extrajudicial statements, requiring a completely different analysis from that applied to statements of defense counsel. So if you are a prosecutor because you've got all the power behind you, you're the prosecutor, you are representing the state, that holds way more weight and that has different rules than if you are a defense attorney, different codes of conduct. All right, so the district attorney creates a video disseminated widely to the media, and we're going to watch it in a second here, but let's dive into what they say. So 25 days after the court order denying the Commonwealth's gag order motion, the district attorney for Norfolk County, Michael Morrissey, disseminated to the media a video statement he created 5 minutes and 45 seconds in length, simultaneously also releasing a full transcript of the video statement to the media. Different media outlets, including NBC Boston, have reported online that both the video and full transcript were released to the media by District Attorney Morrissey's office. This came straight from Morrissey. In the video, District Attorney Morrissey, seated in front of a bookcase of volumes of Massachusetts statutes and court opinions, which makes him look more authoritative, directly addresses the camera, reading a statement that he acknowledges at the start is unprecedented. The full transcript of District Attorney Morrissey's statement, as released by his office, follows, and we're going to, sorry, that was my dog playing with a bone. We're going to listen to this in just just a moment. I wanted to back up and say something, and now I forgot. Oh, the fact that this is unprecedented. It is unprecedented that a prosecutor, a district attorney, rather, comes out and makes any kind of statement about the guilt or innocence of anyone. They should not, and have an obligation to not do that, according to professional code of conduct. So just keep that in mind. You're not supposed to, what were the words? Where was it? I can't find it now, of course, but it was something about the character of the person. Oh, here. In particular, counsel must be cognizant that statements commenting on the character, credibility, or reputation of a witness or conveying information which counsel knows or reasonably knows is likely to be inadmissible in trial and to be prejudicial in effect on the proceedings. So, obviously, a district attorney coming out and speaking for the Commonwealth of Massachusetts saying these people had nothing to do with it, and this person is like 100% innocent, or whatever. This whole family is innocent, and they had nothing to do with it, and it's this one person that's guilty. A prosecutor shouldn't do that. That being said, I'm going to switch you over, and we're going to watch this 5-minute and whatever 44-minute video.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney. The harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop. Innuendo is not evidence. False narratives are not evidence. However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died. Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that this phone did not enter that home. 11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one. Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street. This is a false narrative. Colin Albert didn't commit murder. Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up. They are not suspects in any crime. They are merely witnesses in the case. To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong. They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner. The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found that the line of abrasions on his arm was consistent with blunt trauma, not an animal attack. A grand jury of everyday citizens heard the documented evidence and testimony before making a decision. The subject of that murder indictment enjoys the constitutional presumption of innocence. Why should the witnesses who have committed no crime be afforded less by members of the community? They should not be harassed for telling the government what they heard or saw. I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before assigning guilt to people who have done nothing wrong. And certainly before taking it upon yourself to harass citizens who evidence shows have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason. The internet has no rules of evidence. The internet has no punishment for perjury. And the internet does not know all the facts. Conspiracy theories are not evidence. The idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is, completely contrary to the evidence and a desperate attempt to reassign guilt. Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road. In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so. Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict. And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie. This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial. It needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court. But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
Alrighty, let's get back to the all right, so we have the transcript right in front of me, and I want to just kind of pick apart a couple points that Morrissey says, because oh my gosh, this is just crazy, and this is nuts. So where what there were so many points I wanted to bring up. Like, why even bring up Colin? I really think that this has a lot to do with protecting Colin, because they are so adamant that Colin didn't do it and that he wasn't there in the house. The fact that they're saying there's no fight in the house, that, you know, that none of these people had anything to do with it. You don't know that. Like, that's for a jury to decide. He's not the finder of fact. He's the one that decides whether you prosecute, you go forward with the charges if you have enough. That's not the same thing as being a judge or a jury. All right, so to have them accused is outrageous. Outrageous. Can you believe it? They're just witnesses. Just witnesses. The autopsy, let's talk about the autopsy. So autopsies usually don't say this person didn't lose their life in this regard. It is usually, you know, this is the things that I've witnessed or observed, and this is my best guess as to what happened. But when you've got the investigators standing over you and saying, this doesn't look like a fight, right? This looks more like he got hit by a car, right? That's what you needed to say, right? you kind of, you're leading the examiner to come to a conclusion that you want. And they did not do any kind of swabs on his arms, which we just found out, like I think in this motion, that they didn't do any kind of testing on John's arm injuries. So that's probably why there's no canine DNA testing, which we heard in the last hearing. Judge Cannoni asked David Yannetti if they were waiting on any kind of results for dog or canine DNA testing, and he said no, and that's probably why, because nothing was ever tested and the dog disappeared. And yeah, I'll just leave it at that. All right, so I had a couple other points I wanted to say. So this idea that multiple police departments, EMTs, fire personnel, the medical examiner, and the prosecuting agency all joined in for a conspiracy? No, it doesn't need to be all of those people. It only needs to be a select few that are controlling the narrative. That's how conspiracy and cover-ups happen. It doesn't have to be an entire, all these departments and multiple people. It is crazy that so many people that were in the house have conspired together to keep their mouths shut. That's a conspiracy. But and the people, just the bad apples within the law enforcement agencies and investigators that were not doing things correctly, including Michael Proctor, who, according to Michael Morrissey, had no close personal relationship with any of the parties involved. But we know that is a lie. So that is motive to plant evidence. That right there is motive to plant evidence, because he had close ties with the family. What else? So I'll leave it at that. I think I picked apart. I think I might have missed one other point that I wanted to make, but I think we'll go through more points about it in here. So Boston 25 News reports on the federal investigation of Karen Reed investigation. The investigation into the investigation. On November 29th, 2023, the Supervisor of Records of the Public Records Division of the Office of the Secretary of the Commonwealth, that is a long title, sent a letter to the Norfolk County District Attorney's Office regarding, quote, the petition of Ted Daniel of WFXT-TV, Boston 25 News, appealing the response of the Norfolk County District Attorney's Office to a request for public records made on November 1st, 2021, seeking any letters, emails, or other correspondence Norfolk DA Morrissey or any members of his staff has sent to any DOJ entity that mention whatever individuals that they mention. The Supervisor of Public Records letter indicates that the Norfolk County District Attorney's Office responded on November 14th to the Boston 25 News public records request by identifying, quote, a single responsive record, end quote, and withholding the record pursuant to identified exemptions of the public records law, precipitating the petition appeal. The Supervisor of Public Records letter further indicates the Supervisor of Records understanding that the Norfolk County District Attorney's Office intends on providing a subsequent response to Mr. Daniel and accordingly ordering the Norfolk County District Attorney's Office to provide Mr. Daniel with a response to his request in a manner consistent with public records law and its regulations within 10 business days. Basically confirming that there were communications between Morrissey's office and the DOJ. 3 days later, on Saturday, December 2nd, 2023, a Boston News teaser video was posted online to YouTube announcing a report to be aired on Monday, December 4th, 2023 at 10:15 p.m. about what 25 Investigates has learned, and why are federal authorities looking into the case of Karen Read. The teaser video includes a video audio snippet of a man identified as a former federal prosecutor stating that they are not investigating the unaliving of John, but they are investigating the investigation of his unaliving. So on the evening of December 4th, during the 6 p.m. newscast, Boston 25 News aired a preview report about its upcoming 10:15 report asserting that, quote, our sources tells us that the U.S. Attorney's Office is investigating the investigators who charged Read with the unaliving of John O'Keefe, and that a federal grand jury that's been meeting doesn't appear to be targeting people outside of law enforcement. Interesting. Very interesting. So there are going to be some arrests, most likely, within law enforcement. All right, so the Norfolk County District Attorney was aware of being investigated the same day, December 4th, 2023. The Norfolk County District Attorney's Office provided the defendant with an additional notice of discovery disclosing for the first time 6 letters between the Norfolk County's office and the U.S. Attorney's Office, or the United States Department of Justice, or the FBI. So all of those agencies they communicated with, and we read through all those emails sent between May 2023 and November 2023, all regarding the existence of a federal investigation of the Karen Read investigation / prosecution. That correspondence includes a June 12, 2023 letter from the acting U.S. Attorney, previously the first Assistant U.S. Attorney, informing the Norfolk County District Attorney's Office that, quote, we have no issue with you advising defense counsel about the contact we have had with your office and the information we have shared if you determine such a disclosure is warranted under Mass Arcrim 14. The December 4 notice of discovery additionally discloses that as of December 4th, the Norfolk District Attorney's Office has received no discovery or information about the parameters of federal activity, nor confirmation about whether any witnesses associated with the Commonwealth versus Karen Read have testified before a grand jury. The disclosed letters also included a May 18th, 2023 4-page letter sent by District Attorney Michael Morrissey to the Office of Professional Responsibility at the U.S. Department of Justice, requesting that an ongoing investigation being conducted by the United States Attorney's Office for the District of Massachusetts be transferred to another office without a history of conflict, bias, and abuse of prosecutorial discretion. So he's like, you need to transfer it out of the people who are investigating. You need to transfer it because of all these reasons. So District Attorney Morrissey's May 18th letter specifically discloses that District Attorney Morrissey's knowledge gained 3 weeks earlier that multiple state witnesses in the Karen Read case had received subpoenas to appear before a federal grand jury. That shortly after the knowledge of the federal subpoenas were gained, the first assistant at the U.S. Attorney's Office had a telephone conversation with the first assistant at the Norfolk County District Attorney's Office. So they spoke on the phone, disclosing the existence of a federal investigation involving a number of the witnesses in the Karen Read case, and that since that call concluded, we have confirmed that witnesses testified before the grand jury. District Attorney Morrissey, his May 18th letter also discloses that District Attorney Morrissey's belief that a reasonable person could conclude that the same type of tactics that is weaponized of the U.S. Attorney's Office for personal, political, and retributive purposes are being employed against the Norfolk District Attorney's Office in the Read investigation. His May 18th letter also elaborates on why District Attorney Morrissey believes he personally and his office are being targeted for investigation by the U.S. Attorney's Office, including that, 1, the then ongoing U.S. Attorney has made no secret of her personal animosity toward me, including repeated, crude, outlandish, personal, and professional attacks against me in the media during her time as Suffolk District Attorney. And 2, the head of the Public Corruption Unit at the U.S. Attorney's Office has raised the specter of personal retaliation for his wife's departure from the Norfolk District Attorney's Office. I'm not even diving into all that. So he's got all these reasons why he thinks they're biased and ham it out for him. So the argument: the Norfolk District Attorney deliberately and egregiously violated ethical and constitutional due process requirements warranting the sanction of dismissal. So the Norfolk District Attorney's video statement, which we just watched, coming soon after the court denied the motion for gag order, while specifically admonishing counsel not to engage in the exact kind of public statements comprising the video statement and the Commonwealth's delayed disclosure of its knowledge of the existence of a federal investigation of the Karen Read prosecution and deliberate misinterpretation of its knowledge about that investigation, merit and require sanctions for violating ethical and constitutional due process requirements. Yes, everything that they did require that they be sanctioned, and dismissal of the indictments, while a severe sanction is the only sanction that can remedy the deliberate and egregious violations. All right, so District Attorney Morrissey's video statement requires sanctions. It is well understood that the duty of the District Attorney is not merely to secure convictions. It is his duty to secure them with due regard to the constitutional and other rights of the defendant. Smith versus Commonwealth, citing Berger versus United States. A prosecutor is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, is in a criminal prosecution is not that it shall win a case, but that justice shall be done. So they shouldn't have any skin in the game. They shouldn't want either side to win at this point. Hold on one second. My dog keeps pacing and it's driving me nuts, and it's way before food time and he's not listening to me to go lay down. He's being bad. Alright, so a prosecutor is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartiality is a compelling as obligation to govern at all. So he, like I said, he shouldn't have any kind of interest as to whether Karen's side wins or the Commonwealth side wins. So those constitutional and other rights of the defendant include obligations imposed on the District Attorney by the Massachusetts Rules of Professional Conduct. District Attorney Morrissey's video statement violates numerous provisions of those rules, including Rule 3.8 and 3.6 and 8.4. Alright, so pursuant to the special responsibilities of a prosecutor contained in Rule 3.8, a prosecutor in a criminal case shall, except for statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose. 1. Refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused, and from making an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6 or this rule. And 2. Take reasonable steps to prevent investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case from making any extrajudicial statements. So the prosecutors, anyone in the office, they should not be, and you should make sure that law enforcement officers and, anyone representing the Commonwealth shouldn't be making extrajudicial statements like that that are going to prejudice a jury or, potential jury pool. So District Attorney Morrissey's video statement, widely disseminated to the media, clearly violated these requirements. District Attorney Morrissey personally vouched for numerous named Commonwealth witnesses, explicitly stating in contradiction to the defense theory that Colin Albert, Jennifer McCabe, Matt McCabe, Brian Albert did not commit any crime that night and they were not part of a conspiracy. That they have been forthcoming with authorities, that they have not engaged in any cover-up, that they are witnesses doing what our justice system asks them, and calling the witnesses these innocent people. In addition to the civilian witnesses, the district attorney vouched for police witnesses, specifically stating that Trooper Proctor was not part of a conspiracy, was not at the scene where John O'Keefe's body was found, did not plant evidence, and would have no motive to do so. All assertions contradicting the defense theory and which the district attorney could not know to be true. Yeah, he has no way of knowing any of it. He can have those opinions, he can have those assertions, but that doesn't mean that they are true not until when and if Karen Reed would be found guilty in the court of law. But at this point, their theory is still just a theory just as much as the defense theory, except the defense theory has receipts to back it up. All right. So additionally, district attorney's video, District Attorney Morrissey's video statement explicitly denigrated the defendant and the defendant's counsel, labeling the defense theories a false narrative, a desperate attempt to reassign guilt, a lie, and contrary to the American values of fairness. In short, District Attorney Morrissey's assertion in his video statement constitute exactly what the Commonwealth alleged about the defendant's counsel's statements in his gag order motion, that they go further than zealous representation. They are unsubstantiated proclamations supported only by self-serving speculation and conjecture, likely not to be admissible at trial, and done with the intent of materially prejudicing the criminal proceedings by risking the impartiality of potential jurors. So that was in Morrissey's motion to get the gag order, that quote right there. So he's basically, Yannetti and Jackson basically just like turned his own words against him, because he's showing exactly how they broke the rules here. Such vouching for witnesses by a prosecutor, such denigration of the defense team, the defense theory, would clearly be prohibited at trial and violates the requirement contained in Rule 3.6 that a lawyer participating in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing on an adjudicative proceeding in the matter. The vouching and denigration statements also violate Rule 3.8, requiring prosecutors to refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation on the accused. Indeed, it must be emphasized that District Attorney Morrissey's video statement was created and disseminated hard on the heels of the court's admonition to counsel in its order denying the Commonwealth's gag order motion that statements commenting on the character, credibility, or reputation of a witness or conveying information which counsel knows or reasonably should know is likely to be inadmissible as evidence in trial are more likely than not to have a materially prejudicial effect on the proceeding. Order on, so that was from the Commonwealth's motion. This court explicitly raised in its order the provisions regarding the special responsibilities of a prosecutor with respect to extrajudicial statements, noting that adverse publicity from a law enforcement official provided to the media had the potential to endanger the defendant's ability to receive a fair trial. And District Attorney Morrissey stubbornly, improperly, and in violation of the rules of professional conduct created and disseminated the video statement anyway. Prosecutors are held to a stricter standard of conduct than are errant defense counsels and their clients. District Attorney Morrissey's video statement cannot be justified as fighting fire with fire. Let's go to that footnote. The Commonwealth's right to fight fire with fire is aimed at answering prejudicial irrelevancy argued by opposing counsel. So they're saying that they're just coming back and fighting statements that the defense counsel made, basically. It is limited to correcting the erroneous impression of what the defendant himself was responsible. Commonwealth versus Smith. It is not a license to indulge in improper argument. We have accepted the point only that a prosecutor may properly comment to correct an erroneous impression created by opposing counsel. So they really shouldn't interject unless there's something that they really need to correct. And in this case, that's not the case. That's not what they were doing. All right, so where was that footnote? Where did it go? I don't see the footnote anywhere. Okay. My dogs are driving me fucking crazy right now. All right. Hold on. Alright, I have to yell at him because he doesn't listen. He just paces every 5 freaking minutes for FOOD, even though his time to eat is like hours away. Okay, so anyways, this court has already determined that the defendant counsel's statements and arguments can generally be categorized as responses to the accusations against the defendant and as pertaining to the theory of her defense, and that the statements are therefore permitted under the rules. There was no improper fire to fight, only a burden at trial to prove guilt beyond a reasonable doubt following procedures for selecting a fair jury. The video statement constituted an improper attempt prior to trial to sway potential members of that jury to lighten the Commonwealth's burden. Nor can District Attorney Morrissey's video statement be justified as having, in the language of Rule 3.8, a legitimate law enforcement purpose to curtail any intimidation of witnesses in a pending prosecution. Repeatedly during the video statement, District Attorney Morrissey raised harassment and intimidation of witnesses as an issue. District Attorney Morrissey also raised in the video statement the obligation for his own remarks to be narrowly tailored to the issue at hand while the prosecution is pending in superior court. The vouching for Commonwealth witnesses, the denigration of the defense team, and defense theories were not narrowly tailored to curtail witness harassment and intimidation. The answer to any harassment and intimidation of witnesses is to investigate and prosecute the intimidators, not to disseminate an unprecedented video statement vouching for Commonwealth witnesses and denigrating the defense theories. Let's read that. Indeed, it is exactly what the Norfolk County District Attorney's Office has done. It appointed a special prosecutor who has investigated and brought indictments in Norfolk Superior Court against Aidan Carney, an online blogger known as Turtle Boy, who has covered this case extensively on his website, YouTube, and social media, charging him with 8 felony counts of witness intimidation, 3 felony counts of conspiracy to intimidate a witness, and 5 other related misdemeanor counts. See Commonwealth versus Aidan Carney docket. There's the number. There are no allegations at all that the defendant or the defendant counsels engaged in any witness intimidation or harassment. Yet they're still going with that theory. They keep trying to act like, oh, poor us, the Commonwealth, we're victims of this conspiracy of witness intimidation, which is such a bogus charge. But anyway. So finally, District Attorney Morrissey's video statement cannot be justified by the provisions of Rule 3.6, that this rule does not preclude a lawyer from replying to charges of misconduct publicly made against him or her. District Attorney Morrissey's video statement did not raise or address any public charges of misconduct made against him, and the federal investigation of him and his office had not yet been made public. District Attorney Morrissey's video statement constituting violations of Rules 3.6, 3.8, and 8.4 is professional conduct for a lawyer to... It is professional misconduct for a lawyer to A, violate or attempt to violate the rules of professional conduct or engage in conduct that is prejudicial to the administration of justice. This misconduct by the prosecutor is not simply a violation of the rules of professional conduct, it also strikes at the heart of our system of criminal justice, dependent on observation of constitutional due process, protections, and obligations. We are all afforded those rights, and it seems like when somebody is charged with a crime, they lose all those rights. Or so it appears in our justice system today. It is fair to say that the average jury, in a greater or lesser degree, has confidence that those obligations which to plainly rest upon the prosecuting attorney will be faithfully observed. So people trust in the system. So many people are like, just let it go to trial and let the system handle it. Let it work itself out. But it's not working itself out because the system itself is weighted in, all the resources and power comes behind the state. And most defendants don't have the means, the money, the ability to fight for themselves like Karen Reed has. She's just brilliant in this way, in the way that her and her defense team have gone about fighting her charges. If it was me, I'd be sitting in jail. If it was most people, they'd be sitting in jail and not able to fight these charges. All right, so consequently, improper suggestions, insinuations, and especially assertions of personal knowledge are apt to carry much weight against the accused when they should carry none. District Attorney Morrissey's video statement, violations of the rules of misconduct of professional conduct, has deliberate deprivation of the defendant's constitutional due process rights. His misconduct require that the Commonwealth be sanctioned because of their inability to maintain the rights of Karen Reed in this trial, or in this case, throughout the entire investigation and everything leading up to now. So the Commonwealth's delayed disclosure of and misrepresentations about the federal investigation of the Norfolk District Attorney's Office requires sanctions. Rule 3.8 of the Rules of Professional Conduct also require the prosecutor in a criminal case to make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense. So Norfolk County District Attorney's Office knew for over 6 months that the U.S. Attorney's Office was investigating it. And the Commonwealth's investigation / prosecution of Karen Reed, it knew multiple witnesses involved in its prosecution had received subpoenas to appear before a federal grand jury. It had even confirmed that witnesses testified before the federal grand jury, but did not disclose the extensive correspondence it had with the U.S. Attorney's Office, the Department of Justice, and the FBI until December 4th. So for 6 months, it held on to that information until we finally got confirmation from the FBI that, yeah, you can release these letters. Compounding its failure to make timely disclosure to the defense of this information it knew about, and that tended to negate the defendant's guilt, the Commonwealth failed to make any disclosure at all until it was apparent that media outlets had gained the information and would be reporting it. So the Commonwealth was trying to control the narrative to media outlet, and they failed to make any disclosures in a timely manner to the defense. Elevating this failure to disclose from a discovery mistake to a violation meriting sanctions, the Commonwealth, when it finally did disclose, deliberately misrepresented what it was disclosing. The Commonwealth's December 4th notice of discovery filed with court listed the 6 letters of correspondence being disclosed to the defendant, and also asserted as of December 4th, the Norfolk District Attorney's Office has received no discovery or information about the parameters of federal activity, nor confirmation about whether any witnesses associated with Commonwealth versus Karen Reed have testified before a grand jury. In fact, it knew about the existence of a federal investigation involving a number of the witnesses in the defendant's case because the first assistant at the U.S. Attorney's Office had told it so, and further, the Norfolk County District Attorney's Office had in fact earlier than May 18th confirmed that witnesses testified before the federal grand jury. So they knew this before May, or in May, and yeah, and they lied. The Commonwealth's assertion in its court-filed notice of discovery was blatantly false. All right, we missed both of these. So, of course, the Commonwealth's failure to disclosure and its misrepresentations in its disclosure also violate constitutional due process protections regarding exculpatory evidence imposed by the United States Constitution. See Brady versus Maryland. So they're just violating all sorts of laws. What does it say? Prosecutor may not withhold evidence that would tend to exculpate a defendant or reduce the penalty. So there you go. The Commonwealth is required to disclose exculpatory evidence, as is relevant here, evidence that would tend to impeach the credibility of a key prosecution witness. That would do so. In addition to violating Rule 3.8, the Commonwealth's misrepresentation contained in the Notice of Discovery also violated Rule 3.6, candor toward the tribunal. The dismissal of the indictments is the appropriate sanction. So they're saying, you know, sanctions are sometimes monetary, but they're not always. So the sanction for this, their punishment for all of this should be dismiss the charges. Dismiss the charges altogether. Karen Reed walks free. We'll see what happens. If it's going to Supreme Court, it's a possibility. Yes, most definitely it'll get dismissed. But it's scheduled to go to court March 12th, which is was it 2 weeks away? A little over about 2 weeks away, 16 days from now-ish. All right, so the dismissal of indictments is the appropriate sanction. Dismissal of a criminal case is a remedy of last resort, Commonwealth versus Kronk. Nonetheless, an indictment is the appropriate remedy by prosecutorial misconduct in 2 different instances. First, an indictment must be dismissed for prosecutorial misconduct upon a showing of irremediable harm to the defendant's opportunity to obtain a fair trial. Second, under the alternative principle, prosecutorial misconduct that is egregious, deliberate, and intentional. I'd say that is the case. Or that results in a violation of constitutional rights may give rise to presumptive prejudice. In such instances, prophylactic considerations may assume paramount importance, and the drastic remedy of dismissal of charges may become an appropriate remedy. That's from Commonwealth versus Light, and Commonwealth versus Sinelli, and Commonwealth versus Manning. Both instances are applicable here to require dismissal. First, the defendant's opportunity to obtain a fair trial has been irremediably harmed by District Attorney Morrissey's extensive vouching for Commonwealth witnesses and his denigration of defense theories in advance of the test of trial. Yeah, this is awesome. This is great. This case, in the words of this court, has generated significant media attention locally and nationally. District Attorney Morrissey knew his video statement, which he himself characterized as unprecedented in his over a dozen years as district attorney, would be disseminated throughout Norfolk County, the Commonwealth, and the nation, which, in fact, it was. His deliberate tainting of the jury pool to such an extent that even a change of venue cannot remedy the local prejudice to the defendant constitutes irremediable harm. This prejudice to the defendant, this harm, is compounded by the Commonwealth's deliberate withholding of exculpatory information known to it about a federal investigation regarding its witnesses, exacerbated by the Commonwealth's deliberate misinterpretation about what it knew about that investigation. How differently would District Attorney Morrissey's video statement have hit if he had also disclosed that the Commonwealth's witnesses were being investigated by the U.S. Attorney's Office? His intent to harm the defendant's case, to influence the jury pool in favor of the Commonwealth, is obvious, and that harm is irremediable. Second, District Attorney Morrissey's and his office's misconduct was egregious, deliberate, and intentional, and resulted in a violation of the defendant's constitutional rights. District Attorney Morrissey already knew that this court had had decided to gag defendant counsel's statements. He already knew this court had deemed the defendant counsel's assertions in pleadings, in court argument, and publicly to be pertinent to the theory of her defense, finding that the statements are therefore permitted under the rules. More importantly, District Attorney Morrissey had to be keenly aware that this court order denying the Commonwealth's motion for a gag order had specifically raised the differing special obligation imposed on a prosecutor regarding the defendant's fair trial rights, explicitly cautioning counsel to be cognizant that statements commenting on the character, credibility, or reputation of a witness, or conveying information which counsel knows or reasonably should know is likely to be inadmissible as evidence in trial, are more likely than not to have a material prejudicial effect on the proceeding. And soon after receiving the admonition, he disseminated the video statement anyways. So he was told not to tarnish her character in any way or credibility, but he goes on and he tarnishes the credibility of Karen Reed and her attorneys. And anyone who doesn't believe what they think, pretty much. So clearly denied his motion for a gag order. The district attorney clearly denied his motion for a gag order. The district attorney took it upon himself effectively to silence the defendant, her counsel, her defense theories by using a bullhorn to vouch for the Commonwealth's witnesses, to denigrate those defense theories, to call them false narratives, a desperate attempt to reassign guilt, a lie, and contrary to the American values of fairness. He did exactly what this court cautioned against doing soon after receiving that caution. It was egregious, deliberate, intentional, and resulted in a violation of the defendant's constitutional rights. Dismissal of indictments is the appropriate action. All right, the Norfolk District Attorney's Office has an interest in the outcome of this prosecution other than the interests of justice, requiring disqualification of that office from this prosecution. So because he has a vested interest, he should be disqualified. A due process clause in the United States Constitution and the Massachusetts Declaration of Rights guarantee the defendant the right to be prosecuted by a disinterested prosecutor. Between the private life of a citizen and the public glare of criminal accusation stands the prosecutor. That state official has the power to employ the full machinery of the state in scrutinizing any given individual. So that's what I'm saying. They have all the power. The power is in their hands. A defendant usually doesn't have as many resources as Karen Reed does. So she's lucky in that regard, and unfortunate also, but fortunate that she's able to do this, to hire such excellent attorneys and who have zealously fought for her and looked into this case very deeply. All right, so even if a defendant is ultimately acquitted, forced immersion in criminal investigation and adjudication is a wrenching disruption of everyday life. For that reason, we must have assurance that those who wield the power will be guided solely by the sense of public responsibility, not because you have an interest in making yourself look good because you've stood by these people and now you're sticking your foot in your mouth if you take back your word. that Karen did it. Anyways, so in the same vein, United States Supreme Court Justice Robert H. Jackson observed the prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. That is why the people who prosecute cases are, they're a very key part as to whether someone gets criminally charged or not, and as to whether they get found guilty or not, because the prosecution, it's their duty, their burden to prove that. And a lot of times they do so by publicly disseminating information to the news sources that put the defendant in a bad light, which they have tried to do multiple times in this particular case. So a prosecutor's discretion is tremendous. He can have citizens investigated, and if he is that kind of person, sorry, all the dogs were running down the stairs, and they sound like a stampede. So I don't know how loud it is for you guys, but it's loud for me, so I don't know what the mic picks up. This is supposed to soften background noise for you guys, so I hope that it is. Alright, so the prosecutor's discretion is tremendous. He can have citizens investigated, and if he is that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimations. Or the prosecutor may choose a more subtle course and simply have a citizen's friends interviewed. The prosecutor can order arrests, present cases to the grand jury in secret session, and on the basis of his one-sided presentation of the facts, can cause the citizen to be indicted and held for trial. He may dismiss the case before trial, in which case the defense never has a chance to be heard. Or he may go on with the public trial. If he obtains a conviction, the prosecutor can still make recommendations as to sentence, as to whether the prisoner should get probation or a suspended sentence, and after he is put away, as to whether he is a fit subject for parole. So they have a lot of power, as you can see. While the prosecutor at his best is one of the most beneficent forces in our society, when he acts from malice or other base motives, he is one of the worst. That's awesome. That's a great quote. All right, so that was the end of that page. So Young versus United States. Where are we? There are undoubtedly constitutional limits upon the exercise of the breadth of prosecutorial discretion, as a prosecutor is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest therefore is in a criminal prosecution is not that it shall win a case, but that it shall serve justice. So you, like I said, prosecutors shouldn't have a favored winner in any case. They just want justice to be served. So here, District Attorney Morrissey's own words in his lengthy May 18th, 2023 letter to the Office of Professional Responsibility at the U.S. Department of Justice reveal that District Attorney Morrissey had and has an interest in this case other than the interests of justice. District Attorney Morrissey knew he and his office were being investigated by the U.S. Attorney's Office. Whether he was right or wrong, that investigation was improperly motivated by animus toward him and his office, he clearly has an interest in the conviction of Karen Read other than the interests of justice. Her conviction by a jury, based on evidence presented in court establishing guilt beyond a reasonable doubt, would clearly vindicate him, his office, his investigation, prosecution of Karen Read, to the detriment of any federal investigation of him, his office, his witnesses. By contrast, an acquittal of Karen Reed would be devastating to him, his office, his conduct of this prosecution regarding the federal investigation of him and his office. In short, given his knowledge of a federal investigation and his clearly stated beliefs about what motivates that investigation, District Attorney Morrissey has an interest not that justice shall be done in this case, but to win this case. This motivation to win is evidenced not just in the egregiously improper video statement, not just in the failure to disclose information about the federal investigation, not just in the misrepresentation in the notice of discovery, but in the whole course of discovery in this case. In fact, the Norfolk County District Attorney has slow-walked the provision of discovery since the date of Ms. Reed's initial arraignment in Stoughton District Court, and throughout this prosecution in Superior Court as well. So examples of discovery material requested by the defense but only provided by the Norfolk District Attorney after many months or not provided at all include the following. So this is all stuff that they've asked for and haven't gotten or got late. So digital crime scene photographs from January 29th and February 4th. The defense motion to compel digital versions of these photographs was allowed by the court on October 5th after thereafter ignoring multiple email and other requests for compliance. The district attorney's office finally notified the defense on May 3rd that the iPhone used to take the January 29th and February 4th photos no longer existed. So what happened to it? It just disappeared. It just yeah, okay, to this date, no metadata from those photos have ever been provided. The photos from the crime scene, digital photos from the crime scene, have not been turned over. Confirmation of the preservation of Google geofence data. The defendant's motion for preservation of Google geofence data from all cellular devices was allowed by the Stoughton District Court on April 29th. On May 13th, Trooper Michael Proctor, under the command of District Attorney's Office, sent a preservation request to Google that failed to request the preservation of any data from iPhones. It only requested preservation of all apps downloaded from the Google Play Store, which would only include Android phones. Despite which I'm sure he knew that. Despite numerous follow-up requests, because everybody had iPhones in the house, I think. Despite numerous follow-up requests from the defense, the district attorney's office to this date has not produced any confirmation from Google that the proper geofence data was ever preserved. Inspection of the taillight and housing. The defendant's accident reconstructionist, Carrie Alvino, traveled to Middleborough on May 27, 2022 to investigate the vehicle and to examine the taillight and housing, among other things. When Miss Alvino arrived, however, she learned that the taillight and housing had not only been removed from the vehicle, but were not produced for her inspection at all. Therefore, the defense filed a motion to compel this inspection, which was allowed by the courts on August 12, 2022, after access continued to be denied. The defense followed up with further email and other requests. In addition to further motions to compel, it was not until December 1st that the defense team was finally able to inspect the taillight. Inspection of so they never got to inspect the taillight, and the whole housing unit of the taillight was missing, and the reconstructionist never saw it. Inspection of John O'Keefe's clothing. On May 27, 2022, defense counsel emailed the district attorney's office requesting to inspect the clothing that John O'Keefe was wearing when he was found in the front yard of Boston police officer Brian Albert's home at 34 Fairview Road in Canton. This court allowed the defense's emergency motion to compel on August 12th. So they had an emergency motion to compel because they were not getting the discovery, and the court granted it. So therefore, the defense followed up with further email and other requests, including a further motion to compel. It was not until December December 1st, that the defense team was finally able to inspect the clothing in the possession of the prosecution. So they couldn't even obtain it for themselves and do private testing. The prosecution had to be involved in all of it. All right, so missing ring videos. On September 15th, 2022, the defense filed a motion to compel production of the ring videos from John O'Keefe's home at 1 Meadows Avenue in Canton. That motion was allowed by this court on October 5th for all videos through January 29th. After ignoring that court order and 2 follow-up emails from the defense, the district attorney's office finally notified the defense for the first time on January 5th that in 2023, so a year later almost, that investigators had actually obtained a search warrant for the missing ring photos. So when the district attorney's office finally produced the search warrant, however, it was dated January 26th of 2023. So they never did get a search warrant for the ring camera videos. And remember, we only saw the ring video of Karen backing out when she left to go look for John, but we didn't see it when she came back from the bar and after dropping John off at 34 Fairview Road. And there would have been other times, in the instance when her and John McCabe and Carrie Roberts all inspected the taillight at John's house. We didn't see video of that either. So there's got to be video of those things happening, and we just never saw it. So when the district attorney's office finally produced the search warrant, however, it was dated January 26, 2023, after the district attorney's office had told the defense that the search warrant already existed. In February 2023, the district attorney's office produced a February 10th, 2022 email allegedly from subpoenas at ring.com stating that the ring videos had now been deleted from Dropbox after 90 days. To this date, the defense has not received the missing ring videos. So they're claiming they did put in a search warrant at the time, but the date on the search warrant isn't until January 26th. So, of 2023, so a year later. So yeah, everything from that ring camera was deleted. All 911 calls, including the complete recording of the call made by Jennifer McCabe. They didn't want to hand over the 911 call. And everybody knows we always get the 911 calls. Like one of the first things that's released to the media. But no, not in this case. And not in all these cases with corruption now they're covering up. All right, so anyways, on February 2nd, 2022, at Miss Reed's arraignment in the Stoughton District Court, the defense filed a motion for preservation of all 911 recordings. The district attorney's office produced an incomplete 911 recording on June 10th, 2022. The defense followed up with a motion to compel production of the complete recording, which was allowed by this court on October 5th. It was only after multiple email and other requests over several months that the full 911 recording was finally shared with the defense on February 8th of this year. Not this year, sorry, last year. So a year later, February 2023. Identification of an unnamed female witness at 34 Fairview. On September 15th, 2022, the defense filed a motion to compel the district attorney's office to reveal the identity of that female witness. The motion was allowed by this court on October 5th. Wow. After the district, I can't believe they were like hiding a witness. After the district attorney proceeded to ignore that court order for more than a month, the defense followed up with an email on November 14th asking for compliance. The district attorney finally revealed on the 21st that Sarah Levinson was the female's name. So there you have it. Preservation of samples from John O'Keefe's arm for independent testing. On February 2nd, 2022, the defense filed an emergency motion in the Stoughton District Court for the preservation of evidence, including DNA, blood, saliva, and other bodily fluids. That motion was allowed by the court on that same date after numerous email requests and further motions to compel. The district attorney's office finally revealed in July 2023 that no tissue samples from John O'Keefe's arm were ever taken or preserved. So there you go. He was not, his arm, his injuries, nothing was tested. There were no samples taken. Canton Town Library surveillance footage in its original format. On June 10th, 2022, the district attorney's office produced video footage from the Canton Town Library, but key time periods were excised and or missing from the footage. So there was that 2-minute period where exactly the timing when Karen Reed would be driving by after dropping John off at 34 Fairview Road, which would have likely shown her taillight. So therefore, the defense demanded access to the footage in its original format as received by the prosecution, which was apparent via share file. So on April 26th, the district attorney's office announced in court that it did not have the surveillance videos in any other format other than the DVD produced to the defense. The key time periods remain missing to this date. The Lexus infotainment and telematics system. Ms. Reed's Lexus was seized by investigators on January 29, 2022, when a defense accident reconstructionist, Carrie Elviro, she was sent to inspect it on May 27th. She learned only when she arrived that the infotainment and telematics systems had been removed from the vehicle. Those systems were not produced for Ms. Elvino's inspection on that date. Because it would have shown if she hit something, probably. It would have shown like an impact or her slowing down or speeding up or whatever. It would have shown those things, and she didn't do those things. So that's why it was removed, because it would have exculpated her. So those systems were not produced. After several email requests from the defense, the district attorney's office only made those systems available for inspection by the defense on December 1st of 2023. All the police reports and notes on February 2nd, and mind you, going to trial in March, and they're just receiving information now from the defense. Or, just recently, like December, it's not that long ago. That's when they're receiving info and discovery. All right, so all police reports and notes on February 2nd, 2022, the defense filed a motion in the Stoughton District Court for the preservation of all police reports and notes. The district attorney's office did not produce any notes until September 29th. Those notes were portions from the Massachusetts State Police. The district attorney's office then revealed that notes from the Canton Police and the CERT team do not exist. They do not exist. Why? Why no notes? That is obviously, I'm sure, goes against your procedure. I'm sure you have to mark down your notes after you do a search. So why are Canton Police and CERT team searches not available? Because the Canton Police originally came on scene and they found nothing that would implicate Karen in this. They found the scene as it was, how John was left in the snow to succumb to his own injuries in the cold. And the CERT team, we don't know because of the timing of the CERT team and when they were actually allowed to go and when Trooper Michael Proctor got access to Karen's car. So we don't exactly know the timeline. So I wonder if that's also why we don't have the CERT team notes, because it might shed some light on when the taillight might have been placed. In light of all of these above circumstances, in a case in which the district attorney has a clear interest in the outcome of this trial and has clearly evinced an improper intent to influence that outcome, District Attorney Morrissey and his office must be disqualified from prosecution of this matter. Indeed, to give full effect and rein to a disinterested prosecutor free from taint already. So if you're not going to dismiss the charges completely, which we've already asked for, we want you to give us a new prosecutor who has no interest in this. free from taint, already injected by District Attorney Morrissey in the Norfolk District Attorney's Office. The indictments must be dismissed. So, new prosecutor or dismiss. It's that simple. District Attorney must be Morrissey and the Norfolk District Attorney's Office disqualified from further investigation of this matter, and, if necessary, an independent, disinterested prosecutor appointed to determine whether and what charges are warranted. Regarding the prosecution of Aidan Carney, independent, disinterested prosecutor is exactly the course already pursued. So that is, according to whatever law or rules they're referring to here, as a new prosecutor should be appointed, one who doesn't have any interest. And if not, then dismiss our charges. In conclusion, for the foregoing reasons, the defendant requests that his motion be allowed, that all the indictments in this matter be dismissed as sanctions for prosecutorial misconduct, that alternatively, all the indictments in this matter be dismissed as part of the disqualification of District Attorney Morrissey and his office, and that District Attorney Morrissey and his office be ordered disqualification from further investigation or prosecution of this matter. Respectfully submitted for the defendant, Karen Reed, David Yannetti, and Alan Jackson. And that was submitted to the courts. It was submitted to the courts on January 4th. It was just released this past week to the public, because it was under seal originally when it came out. So that is, and it was certified that they sent it to Norfolk District County District Attorney. Oh, the memo here, I forgot. We got the memo from David Yannetti. He swears that he's a licensed lawyer, licensed to practice in Massachusetts, and he represents Karen Reed, the defendant, in the above matter. I have reviewed the discovery provided by the Commonwealth in this matter, including but not limited to its notices of discovery filed with the court and provided to the defense. I have also reviewed emails and other correspondence that the... My dog is really getting on my freaking nerves. She keeps messing up my screens. Now I lost my place. I have also reviewed emails and other correspondence that the defense has exchanged with the District Attorney's Office, as well as my personal notes detailing other occurrences relevant to this matter. To the best of my knowledge and belief, all facts stated in the defendant's motion for sanctions and for disqualification of the Norfolk County District Attorney and memorandum, therefore, support of whatever, I believe it is the interests of justice for this honorable court to allow this motion. Signed under the pains of perjury. So there you have it. David Yannetti swears under perjury that this is true. All of it. And, I mean, it's too crazy to be true, but it's true. And Turtle Boy says there's going to be a documentary, and my oh my, it's going to be a long one, because they're going to have to really get out a lot of points in this one for Karen Reed, Turtle Boy, the Canton 9, everybody involved. Whew. Wow. So that was something. That's a lot to take in about what the Commonwealth is doing. And if you still don't believe that the Commonwealth is corrupt at this point, I really don't know what to tell you. I can't. I mean, you can give me your hate watches and your thumbs down. That's fine. I'll take it, because you're doing that anyways. But I don't know what will convince you now. If this filing didn't, I don't know what will. Some people are hard. They're thick-skulled. Anyways, I thank you so much for joining me. This was just as usual. It just keeps getting crazier and crazier in this case. So, it's just wild, and I can't wait to see what happens. There is a hearing Monday, February 26th for Karen Reed. Turtle Boy will be there. I'll report on, I'll let you know what happens after the fact. I'm sure all the usual people will be there, and with their flags marching and their signs saying Free Karen Reed. So hopefully, you know, everyone gets out and gets their voices heard. That is important. On that note, you guys heard my voice long enough. I'm gonna let you go. Thank you so much for watching. Take care, and I'll see you next time. Bye.